Hey, good morning, everybody. Welcome back to Law and Legitimacy. It's Thursday, raining in North Carolina. We've got hazy sunshine in northern Vermont. I can't tell if that's because of those Quebec wildfires or not, but I'll enjoy the sun that I can get and send the rain down to Mike. It's soupy up here still out on the back
we
40.
need it down here,
Special thanks to a viewer, Swagmeister, over on YouTube. He points out an embarrassing misstatement yesterday on my part. And it's not as though I didn't know better, since I'd briefed the very issue he flagged before the United States Supreme Court in a petition for certiorari that is pending before that court. But in any case, here's the issue. We were talking yesterday about the Trump indictment. And at least my perspective, the politics of it are enormously interesting to me. The legalities of it are my primary fascination. And yesterday I was trying to focus on that. And I was trying to give you a sense of how a lawyer might look at the indictment and how the mechanics of a prosecution like this take shape. So one of the charges against Trump is obstructing an official proceeding. And that means that he corruptly intended to somehow interfere with an official proceeding. This is charged under Section 1512C2 of the Title 18 of the United States Code. The issue that I misspoke on yesterday was to say that the court was divided, as it were, on its application of the element of corrupt, and that would benefit Trump. That's simply wrong. There were three opinions in the district court opinion in the D.C. Circuit, by Pan, who's writing for the court, by Judge Walker, and by a judge named Katzis. As to the elements of an offense, and I want you to think like a criminal defense lawyer. A person gets charged with a crime, and the first thing you do is you look the crime up and you say, what are the elements that the government must prove? In other words, what are the ingredients? What's the recipe of this crime? And what do they have to prove in order to get a conviction, and how are you going to defend against that? With respect to 1512, one element is corruptly. And whatever action, whatever actus reus, whatever acts a person does to interfere with an official proceeding, it must be corruptly, or it doesn't satisfy the statutory definition at all. In the Walker, or in the underlying case involving Garrett Miller and Jake Lang. Jake Lang is the person that I took the petition for. The judges differed on what the statute meant. The case was challenged by prior lawyers, and I should note that Garrett Miller, one of the individuals in this case, has subsequently filed the writ of certiorari. And if I had to bet money, I'd bet that Swagmeister, the person who noted our error, is either the author of that petition or someone close to him. It's certainly somebody who has inside knowledge on the case. But they point out correctly that two of the three definitions of corruptly result in a majority for that application of the law in that case. And in that case, Miller, Lang, and company were alleged to have used force against police officers in their efforts to disrupt an official proceeding. And the question was the statute intended to cover the use of force against officers in such a context? Pan had no difficulty with that at all, saying corrupt means just about anything. If you mean to screw around with an official proceeding, it's corrupt. Walker said that's probably too broad and covers too much, but clearly screwing around with police officers covers it. And so with respect to Trump's case, both definitions of corrupt, both Walker's and Pan's, encompass a definition of doing something for personal gain. In this case, Trump's personal gain would be to retain office. And therefore, there's really not going to be, at least on the D.C. Circuit's read of that statute, much of an issue as to whether corrupt covers Trump's conduct. The more interesting question is what to do with the dissent in that case from a judge named Katzis. And Katzis took the position, as did the defendants in the D.C. Circuit, that this statute was applied in an overbroad manner, and it was applied in a vague manner, that the statute was intended to cover evidence-related crimes. If you look at Section 1, it talks about altering documents and so on and so forth. And then when you get to Section 2, the word otherwise pops up. and otherwise is limited by the interpretation of the items in Section 1. In other words, otherwise doesn't mean everything, as Pan said, or pretty near everything, as Walker suggested. Otherwise means it needs to be related to evidence, or tampering or altering or mutilating or concealing a record, or it doesn't apply at all. And so they would argue on that view that the Katsas reading of the statute does not apply to Trump. I got several calls yesterday from media outlets ranging from Law 360 to Newsweek asking, what this indictment, what impact this indictment and its reliance on 1512 would have on the Supreme Court's consideration of the cert petition in Lang. And the candid answer is I have no idea. It should make the court more interested in it. We have a statute that was intended to do one thing that's being pressed into far more broad work. I think that the court really should take a look at the issue with respect to the Proud Boys. The Proud Boys weren't looking to keep office. And of course, the argument that they were looking to keep Trump in office and therefore the benefits accrued to some other third party, that becomes sort of strained and attenuated. So again, hats off to Swagmeister. Let the record reflect I stand corrected. And you now all have a better insight into what's going on with the operation of these statutes and the sort of rarefied world of constitutional law and trying to apply standard legal analysis to huge legal problems that carry political consequences. What else is going on out there today, Mike?
Well, I know we wanted to use this as an opportunity to transition to the Trump indictment. Yesterday, we spent quite a bit of time at a I guess a very high level, and what we were able to glean yesterday throughout the day was other legal voices discussing maybe potential First Amendment implications, AKA, political speech being chilled. But I think the thing that struck me the most out of what was available was the notion that there was, from the former police commissioner, but from the former New York police commissioner, a report that was handed over to Jack Smith that discussed an ongoing, I guess, effort to still look through on the part of the Trump camp, still look through issues related to the election, and in particular issues related to voting irregularities or something that would have subverted his being triumphant ultimately in the election. And what that got me thinking about, Norm, was just I think the mens rea, the mental state, the intent element of the conspiracy charges facing him. And I wanted to give you an opportunity, really, and put myself in more of a student capacity and ask you if you wouldn't mind talking about what impact the knowingly false elements or a knowingly false mens rea element of these conspiracy charges will have on Trump's legal defense and what we should expect from that moving forward, and potentially what that has to do with how broad and sweeping the discovery might end up being.
Well, those are great questions, and better ask Trump's lawyer about that. But here we are with our armchair seat at history. Yesterday I was struck in our discussion yesterday by some of the comments in the thread. And I want to address one in particular. I don't recall exactly who made it. But the indictment reads that while Trump was making certain assertions of fact to the world at large, 10,000 dead voters voted, I believe, in one state. I don't recall which it was. And state officials were telling him no. In fact, only two persons voted.
I think it was like there was two references. I think it was like the 10,000, and someone within his camp said it's more like 12, and then he said it was 5,000, and then some state official said it was something like 2.
Yeah. And so the question is, how many people died? How many dead people voted? And if any did, well, that's wrong. But if enough did, it could have changed the result of the election. And that's the so-called outcome determinative, the ungainly outcome determinative language that Smith used in the indictment. And so the question that somebody raised is, well, are you being naive, Norm? Should Trump be prosecuted because state officials told him one thing and he asserted another? What obligation did he have to believe them? How would he know they were telling the truth? And so the question of Trump's mental state and whether he knowingly uttered things that he knew to be false at the time he uttered them will be center stage at trial. And I read a story last night that one of his lawyers said he thought this was an easier case to defend than Mar-a-Lago. And he dared the government to try to show at trial that Trump didn't know what Trump said he believed. I'm not as optimistic about that, but I think what we can expect as a successful defense, I think what we can expect to see in the trial, and I believe the trial will take 6 to 8 weeks, even if it's well and efficiently tried. I realize the estimate for the Proud Boys trial was 6 weeks and it took 5 months. But I think that was largely a function of the fact that we had 8 lawyers and a relatively inexperienced judge, 8 defense lawyers, and we couldn't all get on the same page. And the judge let us make our record, perhaps to the detriment of efficiency. And the result was a trial that lasted easily twice as long as it should have. In the Trump case, at least right now, with a single defendant, there will be somebody in the captain's chair at trial, and that person's going to have to make the strategic and tactical calls. The government's going to have to persuade the jury by circumstantial evidence of what was in Trump's mind. In other words, Trump doesn't have to testify. He can waive the right to remain silent and take the stand and let everybody know just what he said, just what he believed then and what he believed now. Will he do that? I bet he probably does. It's hard for me to imagine him sitting at trial and not testifying. But before he testifies, his lawyers will be looking for a way to see if they can prevent the case to get to a jury. And I suspect there will be motions to dismiss filed before the jury is seated. And they may claim that there is insufficient evidence to show that Trump didn't harbor a genuine belief that the election was stolen. The government will respond by reciting all of the factual allegations that were in the indictment, including the number of state officials, the number of advisors, the number of people close to Trump who told him there was no evidence that the outcome of the election would be affected by whatever fraud existed. And then the court will be invited by the government to say a reasonable jury could conclude that based on the facts and circumstances presented to Trump, as reflected in the evidence, he knew or should have known that the comments he was making are false. That should have known prong. Now, one way to show a person knew would be to get them to, have a secret recording. I know it's all bullshit, but I'm going to do it anyhow. Or he says at a meeting, I don't care if it's not true or not. This is what we're doing. Say it.
Well, and to a certain extent, Norm, even in the indictment, I think we have something where they're according to Vice President Pence, Trump said something to the effect of "You're too honest." So they've tried to layer in things like that into the indictment, but just to get
they have, and that's interesting because you got to assume that's their best evidence. That's the best evidence that they have about what came out of Trump's mouth about acknowledging that he knew that what was going on was false. But it's one thing to say to somebody you're too honest. It's another thing to say you're too honest, and I know, but I want you to lie. And you can say, well, if you said the former, the latter is implied, and it's a reasonable inference. And my hunch is a court will let the case go to a jury. There may be different First Amendment grounds for attacking the case. We'll talk about those on a later date. Let's stay focused on the issue that's raised here, and that is this issue of how the government will show knowingly. So the government, I think the case
what
will.
I'm doing on the screen, Norm, sorry, what I'm doing on the screen, there are 36 instances of the word knowingly in a 45-page indictment, and I'm just going through. So as you see the pages flipping, I'm just flipping the page so that you can see how often the word knowingly is layered into this indictment. Sorry, Norm.
No, that's right. So in order to show knowingly, they're going to have to show either one of two things: direct evidence of what Trump knew, meaning his words as uttered to others, or the inferences, the reasonable inferences from those words as uttered to others. And of course, they don't have direct access to Trump's testimony because he can't testify, but his statements to others are admissions of a party opponent or arguably statements against penal interests. Both of those are exceptions to the hearsay rule. So his statements will come in. If in order to buttress those the statements, to place them into a larger context, the government will produce a lot of witnesses who told Trump what they told him. There were only 2. There was no evidence of smuggling votes into Detroit. All of the allegations from the various things in the complaint, the various allegations in the information, and then they will say to the jury, having been told all of this, Trump knew. He had to have known. There was nothing to what he was saying. And the defense response will be that's speculative. And the court's response will likely be that the case will go to a jury on the grounds that, given all of that evidence, it would be reasonable for the jury to infer that Trump had knowledge of these facts in the world. And then, although the law is that a person does not have a defendant has no obligation to produce testimony at all, there'll be a subtle burden shift, and it won't be a legally sanctioned burden shift, but the jury will sit there and they'll be expected to be told what data, what other than a raw desire to win and to hold power informed Trump's belief, whether in good faith or not, that the election had in fact been stolen. And so I suspect that in the defense team, and I assume there will be a team, at least one lawyer will be tasked with assembling sources of information and data that Trump could have relied on to harbor and come up with a good faith belief that the election had in fact been stolen and the information he was being given was trustworthy. And to end finally, Mike, at the point you raised, that's the significance of the Carrick report and other things like that. And so if there's enough of it out there, enough information out there from other sources, whether credible or not. And I want to avoid a broader political discussion right now because I just think the broader political discussion obscures the legal issues. Obviously, it's the ocean in which these fish are swimming.
Right.
But let's focus today on the fish. You know, if there's enough information out there that suggests that Trump could have been reading things from people he relied on and that he regarded as reliable, and that it's not entirely insane to think were reliable. For example, you know, if Marjorie Taylor Greene said the QAnon shaman told her the election was stolen and Trump says, yeah, I'm going with that. I mean, you know, that may not be a reasonable belief in the eyes of a jury. It certainly wouldn't be in my mind. And so I think that's where the case is going. And so I think they're going to have to show that Trump had that Trump knew what he was saying was false, and that if he believed, and the tricky question to me is, could he be wrong, and nonetheless be right as a matter of law? In other words, have a defense as a matter of law. And I hope the answer is yes, because what I was trying to say yesterday is the thing that terrifies me about this prosecution, and the thing that makes this indictment the most terrifying indictment in the J6 cases, is it's the first time that political speech by a sitting president has been the focus of a sitting elected official, has been the focus of a criminal investigation and a criminal trial now that I'm aware of in United States history. And what makes it particularly chilling is this is an example of a misinformation, disinformation prosecution. And so this case suddenly becomes a sentinel case in the history of the development of our law, where a person can now, if this prosecution succeeds, be held to act corruptly if they use mis or disinformation to achieve their political goals. Man, if that was the standard, I think most politicians in this country would be doing life breaking rocks at Leavenworth, and we may as well get rid of the elections and go right to a republic of virtue. So that's my take, and there it is.
Well, I think that's valuable. I can't help but to think that in the war that will be over the knowingly element here is going to be ugly. I expect that the prosecution will really focus on the members of that Trump camp that were informing him of these certain things as a mechanism by which to establish that he had knowledge of some extraneous, source to say that what he believed would have been unreasonable. And the reason I'm focusing on that, Norm, is because it clear, that is sort of a divide and conquer strategy, right? It
is.
It goes beyond just whether the exogenous or extraneous information being used by those advisors was reliable to say that Trump had hired these people for a specific reason. They had demonstrated subject matter expertise and a command of certain things, that they assisted him in making decisions on matters of growing importance in various areas. And why would he thus depart from trusting them on this issue in particular, right?
Yeah, I mean, there it is, and that's going to be a significant part of the case. More, I mean, and the fact that no one else has been indicted, I guarantee you that at least 6 other phones are blowing up right now, and those are the lawyers for the unnamed co-conspirators, and they're being said, look, we're serious. We got the big guy. We're coming after you too. Search your memory, search your notes. What else did Trump say? And I mean, and so if I'm the prosecutor and I'm calling Sidney Powell's lawyer, he called her crazy. Did he ever have that discussion with her? How did he react when, yada, yada? Was he rolling his eyes when she talked about releasing the Kraken? When she started talking about the, Dominion and the Venezuelan, Cesar Chavez's efforts to control Dominion and thereby reach somehow into American politics? How did Trump react? Because his demeanor in any meetings that he had with her as he evaluated her claims could be as powerful as any words that he spoke. And the indictment already says he referred to her as crazy elsewhere. What else? Who else did he say that to? And I guarantee you he said something else about her, or he reacted to her in ways that will be rebound to her detriment or his detriment. And efforts are probably being made now to recruit her as a witness.
100%. Something else I think about is how relevant the knowledge that that this situation had been war gamed by both political parties, and the issue of the fraudulent electors or the fake electors and stuff like that. The fact that I think there was the Podesta memo that was somehow leaked and became available, but then USA Today and Time Magazine have respectively covered, the potential outcomes of the 2020 election well in advance of the election, and went into great detail about what either side was likely to do and what sort of legal mechanisms were at their disposal to actually challenge in a manner not inconsistent with what we've seen Trump's legal team do state to state. I do wonder whether Trump's legal team will be diving into that or seeking to at least harbor the zeitgeist that is, this would have been what the other side did because everything that we did was considered reasonable and within the scope of normal political procedure, especially in an election that was going to be as hotly contested as everybody agreed well before it got here. Right?
No, I think that's right. You're referring to the work of the Transition Integrity Project. And I think that we saw a little snippet of what they were up to when we saw reference to the so-called 1776 document in the Proud Boys trial. This was a war-gamed document about ways people might seek to interfere with counting of the electoral votes. A lover of Enrique Tarrios forwarded a portion of it to him. The feds found it in his electronic data and introduced it as proof that they had a plan to subvert the Capitol. Know what they did is they had access to documents about others who war gamed these things out. It was a fraught moment. Matthew Kyle asks, what happens if Trump's legal team or whoever can prove in court there was voter fraud in a state or states? Well, that would be huge. And of course, the court, we await that proof. I mean, the 60 some other efforts have failed. And, there's going to be a little bit of a problem. Trump's team may make an effort at that. And then the government will claim relevance. And you'll say, well, how could that not be relevant? Well, the question is, what did Trump know at the time? At the time he made these utterances, if he didn't know things that we now know, arguably that can't shed light on his state of mind and might confuse the jury. And some trial judges might keep that out of evidence. But I do expect, Matt, that his legal team will mine the data, as it were, mine everybody's files and come up with as much as possible to show that there were reasons for Trump to believe that the election had been stolen. And let's not forget, as Mike just pointed out with respect to the Transition Integrity Project, this was a special election. We were still locked down from COVID, and there was going to be a record number of absentee ballots. And people said early on, there's going to be a difference in, there's going to be a delay in counting this, and this is going to happen. And so I think all of those issues will be litigated thoroughly. It wouldn't surprise me to see this case also extend into the months-long range, depending on what the trial judge permits into evidence.
That's exactly why I reference how broad discovery could be in this case. I see all of these things as integral to both sides attempting to prevail on that issue of his mental state. And then before we transition to dunking on LeBron, I just have to reference Matthew Kyle is who clipped the video that I have here on the screen. I'm not going to play it right now, but it is hilarious. So if you're following us on X at LawPod Daily or at Pattis Norm or at at Michael Boyer _ You can find this from yesterday's stream. Just a quick 5-second laugh for you between me and Norm there.
What happened? I didn't see it.
Sure you did. Let's see. Hold on. I'll play it.
Man, when these things are done, I just move on. I'm trying to read the fucking indictment and explain it to people.
I get that.
I'm trying to read the fucking indictment and explain it to them. I do remember that. All right. So LeBron, what up with LeBron?
Well, I'm not sure, and I'm also not sure exactly how to introduce this topic, except to say that that he's in the news now because of his I Promise school in Akron, Ohio, where he's from. The I Promise School was, I think, launched in 2018 as a product. It's a public school, so it's a product of not only the LeBron James Foundation, but also the Ohio taxpayer. I think taxpayers in Ohio have contributed to about $8 million in funding for the school. And the report that I think was broke by the Akron Beacon is that there are no students that have passed the math scores up to 8th grade in like 3 years.
How many students are in the place and how long is the school?
So I did some digging, Norm, and this is why I said I was a little confused on how to begin this, because I think first and foremost, our interest here overlaps on the concept of education and understanding that that education is a very powerful tool, not only for practical knowledge, rote knowledge of certain things, but also self-esteem and confidence in the belief that one can go and continue to be sort of autodidactic in a manner that helps facilitate their own maturation in time.
Autodidactic means you can teach yourself. I
correct.
know some of you were making fun of us yesterday about throwing around these multi-syllable words. So you're now an autodidact. You can look it up in the dictionary.
So I'll say this right here from the New York Post article. The last time students passed the state's math test happened when they were in the 3rd grade, per the report. One Akron public schools official described the test results as discouraging. Now, I think to be fair to the report, this school targets specifically at-risk youth, and I'm putting that in parent or in air quotes there. At-risk youth being those that are, from an academic achievement perspective, far behind. Now, I don't know how far behind. I also don't know whether there are any other diagnoses that correspond to the overwhelming demographic of students there. But I do know that this school as a whole is focused on what's regarded, Norm, as a wraparound approach to education. And, you might say, well, what the hell does wraparound mean? Because I
did say that. Yeah.
So I'll back to the New York Post article. The LeBron James Foundation did have a statement, and I'll read the statement here, then we can talk about wraparound, because that's where I was trying to understand what the hell is going on. Their statement, when confronted with, I guess, the disappointment of the board and of public education officials, et cetera, quote, "When we started this work to wrap around students through education, we entered this partnership with Akron Public School for the long haul. Because this work requires long-term commitment, hard work, and a lot of love and that's what we bring each and every day, because the I Promise School is more than a school. We're here for the ups and downs, and we'll continue to wrap around our students and their entire families so they can be successful in school and in life, no matter the challenges and obstacles that come their way." And that's right before it was reported that the principal will be replaced come this fall.
So that's a long-winded way of saying it takes a village to raise a child. Right? So what is wraparound?
So I found the National Wraparound Initiative in trying to do some diligence on why this buzzword wraparound was being used very intentionally. And they were clearly not interested in answering why it was that objective metrics or objective standards could or could not be met by those within their school, especially over a 3-year period, and especially with the likes of LeBron James, his celebrity, and with the funding and resources. And in particular, that was referenced by one of the board members, that it's disappointing not only just on its face, but it's disappointing because of all the resources that are poured into this school and what the school and its students have at their disposal. So this wraparound initiative, Norm, seems to me to yield a different perspective on what this school, like what the goals of this school actually are. It kind of feels like a glorified daycare / welfare situation. And I say that because you can see here that it lists supporting community level planning and implementation, promoting professional development of wraparound staff, ensuring accountability, sustaining more vibrant, interactive national community of practice. That's their overall initiative.
Well, how about teaching kids to read and write?
But it's really interesting because that's exactly right. We can go to the WRAP model and say, okay, well, what are the basics of wraparound? And it says that wraparound differs from many service delivery strategies in that it provides a comprehensive, holistic, youth and family-driven way of responding when children or youth experience serious mental health or behavioral challenges. So I am not really sure why this story exists, except for the fact that it made headlines a few years back because someone like LeBron James was putting his time and effort. And by the way, he's listed as the principal of this school, if I'm right.
LeBron is?
Yes, I'm trying to find the article here. But yeah, he's listed as the school's principal, or vice principal. Which is interesting to me. And so, okay, why are we talking about this on Law and Legitimacy? It seems as though this has been an initiative ultimately to pour resources into a certain area of Akron, and to pour resources into families. And it's really, they talk about longer school days, family resource centers, all sorts of stuff that starts to look and feel less like a traditional education institution or initiative and more sort of recreational center, almost like I call it a daycare. I'm not trying to be condescending, but it doesn't at all appear to me as though that education is the primary objective of the I Promise school.
Well, or maybe he's got a different view of education, and that education's, that a child can't become educated unless his or her basic emotional, physical, and mental health needs are met. And in
I
cases,
don't necessarily disagree with that. I think
I don't either.
But I think the demographic, this at-risk demographic, these students that are far behind, I think that tells more of the story than the methodology being deployed. Right? Is that there is this systemic issue with the larger Akron public school system, and somehow this has become sort of the containment area, like the magnet to pull all of that into one place.
Well, I think what it would be interesting to me is if the means existed for someone, and take an educational expert, to look at the entire population of students in Akron and determine what at-risk means, and so identify the number of at-risk students and then evaluate their placement and see whether kids who fall within the category of at-risk are doing any better with LeBron James's effort or not.
It's categorically true. I read a statistic and I need to find it, so I'll try and fact check this and bring it tomorrow or whenever we readdress this. I think this school is performing worse than 99.4% of all other public schools.
Well, in that case, the effort fails, and critics of James have something to crow about. I think one of the reasons I worry that the case is prominent is because LeBron James illustrates the fallacy of superior skills. And what do I mean by that? Just because you can dribble and dunk as though God made you for the express purpose of nothing other than basketball doesn't mean you can do everything. But yet with wealth comes the ability to experiment and to impose your will on others. And I think LeBron has become a prominent spokesperson and outside of the realm of basketball. And he's using his wealth to try to transform society into a vision, I guess a more inclusive vision, as he might say, a more diverse vision. And those of us who are somewhat skeptical of the DEI agenda look at somebody like LeBron and at some level take some Schadenfreude, some dark pleasure in his stumbling, and
right.
So I want to own that.
I'm one of his biggest critics at this point, and he's nearing the end of his professional basketball career, but anybody who's close to me knows that I have very little respect for the person that LeBron has evolved into. We also we can't overlook the fact that LeBron is not exactly a beacon of scholastic excellence. He went directly from high school to the NBA, and he's been recruited in some form or fashion since he was about in 6th grade. So this isn't something that, you list him as a vice principal. And then I have this image on the screen very specifically to illustrate that my belief that I don't think that this school is at all about, primarily about education. Please look at the context in which these students are operating, the branding, the vibrant kind of color dynamics and here and there, and all of the artwork on the walls, very distracting, but very good for photo ops. Right. You've got here LeBron with the photo op, but then I think I saw up here as well. It became clear to me that everything that's being done in and around this is mostly about the optics and making it look good. I sincerely, and this is very cynical on my part, Norm, and I admit that, I sincerely do not believe that the factors of this school, the LeBron James Foundation, nor Akron Public Schools has any realistic expectation of achievement for the students that attend this school. I think it is something to base against the visibility of how desperate things have gotten in the Akron region over the last 20 or 30 years.
Possibly, but yet we also favor local control of schools and parental choice as a matter of federalism. And so the LeBron James experiment is one that we should reevaluate, pay close attention to. The fact that local control is important doesn't mean that standards don't exist. And whether they're making a serious effort there to adhere to recognized educational standards might be an open question based on the results of these test results. Let's keep an eye on that in the days and weeks to come. So what are we going to talk about tomorrow?
Yeah, Severe Conservative, thank you for being here. Great job talking the indictment on Wednesday, Norm. And today's Thursday, so Severe Conservative is giving you props for yesterday as well.
And dropping the F-bomb.
And then I'll take the up for the analysis of branding. I think that has a lot to do with what we're seeing there. Tomorrow, I'm going to look into, we may be talking the O'Bannon case and EA Sports, and then the Brander v. EA Sports, or I think I just mislabeled the name of the lawsuit. EA Sports is in another lawsuit over name, image, and likeness. The O'Bannon decision is responsible for the fact that we don't have an EA Sports college football video game for the last decade. And now with the name, image, and likeness, the NIL stuff spreading everywhere, we have major conference realignment in the college football sphere as well. I do want to take a second and analyze the legal landscape of name, image, and likeness through the perspective of EA Sports and video games.
Well, let's do that, and let's get back at it. So thanks, folks. It's been a busy Thursday. We'll have a fabulous Friday, or at least we'll have a Friday. Let's see what happens. Thanks for listening in. Find us where you do. Give us a thumbs up. Give us a 5-star rating, or as Mike says, leave us alone. Otherwise,
yeah, leave us 5 stars or leave us alone. I think, find us every day here, 8 a.m. Rumble Video, YouTube Live, and X Live. If you're there, biggest thing you can do for us is give us the thumbs up. So smash that, as they say, bang that thumbs up for us. And if you're feeling inclined, please share it on whatever your personal social channels are. We are trying to expand our sphere of influence, and I have a feeling that those of you who show up every day know that you're sitting on something valuable. So as much as it might be an advantage to you in conversations with those close to you, please share it. Norm and I would like to grow this in due course, so we appreciate you very much. Find us on Apple Podcasts, Spotify, Google Play, Overcast, Audible, wherever podcasts are found. Norm, I will see you tomorrow.
You will. Take care, everyone.